Morning, everyone. We've got quite a few of you here. We're just going to wait a minute or two to let others join before we start. Morning for those joining. I'm just going to leave it one more minute. We've still got people joining, but the numbers are starting to level off a little bit. Okay, I think we'll make a start. Good morning. Very warm welcome to our September, not quite in October, HR Club on conducting sensitive workplace investigations. My name is Sarah Martin. I'm a director of Narrow Key HR, and I'm introducing the session today, which is going to be delivered by my colleagues Lisa Reynolds and Simon Martin. If you've got any technical issues today, I'd check your settings first of all in the Zoom banner across the bottom. If that doesn't resolve it, please feel free to leave a message in the chat box and we will try our best to help you. Or you could try disconnecting and rejoining the session. If you have any questions throughout today's webinar, we will be doing a Q&A towards the end of the session. If you can, please pop those in the Zoom Q&A box and not the chat box. At the end of the session, we're going to launch a couple of feedback questions. So please do stay to complete those if you can, because it's really useful for us to see your feedback. Also, if you have any suggestions or ideas for things you would like to see us cover in future sessions, then please also put those in the chat box at the end. This webinar is being recorded and we will aim to send you a copy of the slides along with the recording in the next few days. Before I hand over to Elisa and Simon, I just want to give you the date for the next session. The next HR Club is going to be on the 11th of December, and we're going to be doing a session on managing absence. We find that this is an area that can be particularly complex. It's one of those things that might look relatively straightforward when you look at the policy documents, but in practice, it can be quite tricky to navigate. So we thought it would be useful to cover that. Okay, so I'm now going to hand over to Lisa, who is going to start today's session. Thank you.
Good morning, everyone. Thanks, Sarah, for the introduction. Just want to start by looking at what we're going to cover today. So what we're going to be doing is understanding trauma and its impact, the importance of a trauma-informed approach, and the benefits for your individual employees and the organisation itself. So running trauma-informed investigations involves a sensitive and empathetic approach, and essentially to ensure the well-being of all the parties involved, particularly those who have experienced any trauma. So what actually is a trauma-informed approach? And why is it important? Well, it's essential to foster trust and to minimise harm and ensure fairness in the process. And there are benefits to the organisation in this approach. It will help you comply with your legal duties, not only the new sexual harassment prevent duty, but also the proposed changes under the Employment Rights Bill. It creates a safer workplace and a psychologically safe environment for your employees. So let's look at the common trauma responses. It's important to understand a little bit about these, and particularly how it can affect memory, behaviour and communication. And trauma is how the body and the mind react to a perceived threat. So we have, first of all, fight, so coming out confrontationally and confronting the threat aggressively. So examples of that could be physical actions like kicking or punching, verbal outbursts, being argumentative, and it can also manifest itself in quick anger or irritability. And then we go on to flight. So this involves escaping or avoiding the threat. Examples can be physically leaving a stressful situation, avoiding certain places or people, engaging in activities like excessive exercise or substance abuse to avoid confronting the emotions. So then we go on to freeze, and this involves essentially being immobile, or what you could call playing dead. So feeling stuck, unable to move, disassociating yourself from the situation. For example, binge eating as a way to cope with overwhelming emotions. And then we go on to fawn, and this involves trying to please or appease the threat, which can be quite confusing in an investigation. So we've got people-pleasing behaviours, over-apologising or being over-accommodating to avoid the conflict. It's important to understand these in the first instance. So what are the key principles of trauma-informed investigations? So let's look firstly, safety. So that's not just about physical safety, but that is also about ensuring emotional and psychological safety for everyone involved. And when we talk about empowerment, what do we mean by this? Well, where possible, giving individuals control over the process. For example, where the meetings are held for them to make them feel more comfortable. Having input in the process itself, and transparency, in a trauma, in any investigation, but particularly where trauma is involved, clear communication of the processes and the next steps and outcomes is essential. So keep in touch at every stage of the process and explain where there are unavoidable delays. Try and keep to the timescales where you can, but where you can't, explain why not. And respect, and what do we mean by this? It's about, I suppose, approaching every interaction that you have during the investigation with empathy and dignity. So when we're talking about roles and responsibilities, consider who you're going to use as an investigator. Wherever possible, different people at escalating levels of seniority should conduct the investigation, the formal hearing and appeal process, although we know that that isn't always possible in smaller organisations. And you should obviously, as in any investigation, avoid appointing people to carry out those roles who have been involved in the issue previously or have knowledge of it. So appointing people from different parts of the organisation who have no or far less knowledge of the people involved would be helpful and possibly more comfortable, particularly for a complainant who has suffered trauma. And when necessary, consider using an experienced external investigator to ensure objectivity. And then take into account the particular sensitivities of the case itself. For example, a woman who has been sexually assaulted may be more comfortable talking to a female investigator. And if possible, that should be arranged. So how do you prepare for the investigation? So investigators should understand how trauma affects individuals to avoid misrepresentations of behaviours or responses. We've touched upon these earlier in terms of fight, flight, but people can have very different responses to trauma, and it is important, particularly I suppose in relation to fawn, to understand that these are possible responses to trauma and can affect the way people behave, their memory, and the perception of the incident itself to outsiders. The investigation should be tailored to specific trauma-related factors where possible, and to select an investigator based on their expertise where possible. Building knowledge of trauma-related issues, so create a risk assessment to identify the potential harms in any particular investigations and plan mitigations for those possible harms. And I think the last one here is really important about avoiding delays and prioritising the investigation. Taking part in an investigation can prolong the trauma for the individual. So delays in the investigation can exacerbate this. Now, the Equality and Human Rights Commission in their guidance suggests that you should have target timescales for each stage of the process, and these should be communicated clearly to the complainant. And the timescales should be prompt, but they should also allow for a thorough process. And obviously, always remember that timescales should be realistically achievable so that they can be kept to, other than in exceptional circumstances. And when there are delays, explain these and explain why there have been delays to the complainant. So what do we mean by creating a safe environment for the individuals? And how do we prioritise physical and emotional safety? So I think privacy is key. Treating everything confidentially, ensure that each and every interviewee understands their obligations around confidentiality, and provide reassurances to those interviewees. Only share what you need to share with the interviewees, and ensure that each of them feels secure. Choose a private, comfortable setting, but not forgetting that some people may prefer to be interviewed remotely. And then support systems. Encourage access to counsellors or trusted support persons. If your organisation has an employee support programme, direct those individuals to it. And then allowing interviewees to be accompanied. You should extend the right to be accompanied by a colleague or trade union representative to the grievance investigation meetings where it is reasonable to do so. But also consider extending the right to be accompanied to allow persons other than colleagues or trade union representatives where appropriate. But also bearing in mind the need to maintain confidentiality in the investigation process. In certain circumstances, employers are would be legally obliged to extend the right to be accompanied in order to comply with legal obligations. So what do we mean by this? So, for example, an employer could be required to, an employer could allow the worker to be accompanied by another person if it is necessary to comply with the duty to make reasonable adjustments, for example, for a disabled worker. You could have a situation where you need to help a worker overcome a language barrier, and to not allow a different, a anyone other than a colleague or trade union rep to accompany that individual could amount to discrimination. But also you could have a situation where you need to maintain trust and confidence between the employer and the employee. For example, if a vulnerable employee needs emotional support. So what do we mean by this? And can I give you an example? So perhaps our worker has made a complaint of sexual harassment. She's not in a trade union. And it could be unreasonable in a situation such as that to expect that individual to recount explicit details of the harassment in front of a colleague. Such a person could find it very stressful and upsetting to talk about the matter and is likely to need emotional support to do so. So it would be reasonable in those circumstances to allow that employee to be accompanied by someone who's able to provide that emotional support, such as a friend. I mean, the friend will undoubtedly know about the situation already, but they should also be made subject to the same confidentiality as everyone else involved in the process, as employees would be, and the trade union. So that's where how we would create a safe environment. But we'll move on now to the investigation process itself. And I'll hand you over to my colleague, Simon, to continue with this part of the webinar. Thanks.
Thanks, Lisa, and good morning, everyone. So we've set the interviews up. So we're in the interview now. So the first thing to think about is how you're going to approach the interview. And I think one of the most important things is patience, because what you'll often be asking someone to talk about is something they're going to find very stressful. They might feel damaged by what's happened. They might feel embarrassed by it, and they may well feel it difficult to talk about. And so it's important that you emphasize they need to take as much time as they need. And so just practical steps. If you're setting up an interview, make sure that you've got time. You don't have to go off to another meeting straight away, because it may take, let's say, 45 minutes up to an hour, let's say, before the person is really prepared to talk to you. You might just need to sort of talk around the process, just for them to feel comfortable to talk to you about something that they're finding very difficult to talk about. And so it's important that you are giving that message and you are saying, take as much time as you need. I know this is going to be difficult to talk about. Sorry, Lisa, we've just gone. There we go. Yeah, so it's important that you are letting them know that this is difficult to talk about, and they need to take as much time as they need. And they need to think about the questions. So I think one of the main things is you need to remind yourself, this isn't a disciplinary, so you're not cross-examining anyone. This is you are just at the fact-finding exercise. And so you should just be using open-ended, non-confrontational questions. You don't want to be cross-examining someone. That's not to say that you can't put the other person's version of events to that person, and that again needs to be handled sensitively and with empathy, and say, look, you might find this difficult to hear, but it's important that I put the other person's version of events to you, and I'm going to give you a chance to respond to that. And again, emphasizing that they need to have time they may need time to process what they're hearing and give a chance to respond. And they may need to take breaks in that. And often I find when I'm doing these sort of interviews, they need to have a break, and they can become quite emotional, and it's important that they be given a break as long as they need, just to sort of compose themselves, and they can come back. But so we're not saying you can't put the other person's version of events, but it needs to be handled sensitively and avoid confrontational questions, and also think about the questions, do you, for example, need to ask someone about their detailed sexual history? Is that relevant? Is that something that is part of what you're needed to look into? And the other thing is just to think about letting them know what is going to happen to their evidence, because they mustn't come away with the idea that this conversation is essentially just between you two. So you need to let them know that we may well be using what you've said in conversation with others to check other evidence, and certainly it will be appended to our investigation report, and you need to explain that to them at the outset. So when we do interviews, we have a preamble at the start of our interview, and that preamble is also set out in the interview notes when we send it to the people, so they're very clear what may happen to that evidence. And quite often you can't guarantee what's going to happen to that evidence, because let's say this ends up in an employment tribunal, then there'll be disclosure from an employment tribunal. Sometimes people submit subject access requests, and so you shouldn't be trying to give reassurances about what may happen to that evidence they're giving you. And so it's important that you are clear about what may happen to it, and get them to essentially to agree to that. And then the next one is, as Lisa's already mentioned, this: explain each step. So when you're doing an investigation, you need to make it clear, this is the fact-finding exercise. I will interview a number of people, and then I will prepare an investigation report, and then that investigation report will be passed on to X person, and they'll decide next steps. So as the investigator, you often have little say beyond your area. So it may need to be someone else who is essentially commissioning the investigation, who's going to have a better overview about each steps. But it's important that the person who has been traumatized has had explained to them what's likely to happen, and when it's likely to happen. And as Lisa mentioned, the Equality and Human Rights Commission really want or encourage employers to set out a timescale and stick to it, and essentially this needs to be a priority. So can we move on to next slide, please, Lisa? Thank you. So when you're doing the interview, this is active listening. So this means listening carefully, so you're not having to ask someone to repeat themselves several times, because that may be difficult and challenging for them. It depends on what you're talking about. So it means capturing and being clear about what they are saying, but not really asking them to repeat themselves several times. But also it's about watching for any clues in body language. And so one of the things with investigations we talk about is the cognitive load of people. So if they are doing lots of hand gestures, for example, and then at some point when a difficult question happens, they stop the hand gestures, or they stop they're talking at a particular speed, and then they stop and pause. It's worth noting that, because that may indicate that is something they're having to think quite hard about. And so again, it's worth noting that any sort of change of pace, or if you notice people sort of like say stand up or put their hands to their mouths, or you can notice certain clues from things that they are doing. So it's not just what they are saying. Then the next one is accurate documentation. So you may need to consider getting a note taker. Well, you should certainly have at least a note taker with you. For this sort of evidence, you don't want to be trying to do this note taking yourself. You need to have a good note taker with you, and you may also need to consider having it recorded, just so you've got an accurate record of what's said. And it's important that that record, as quickly as possible afterwards, once you've checked it through, is sent to the person to review. So you are making it so it's as clear as possible and as accurate as possible before you move on to the next stage. And certainly, just planning ahead in your investigation, you don't want to find yourself interviewing, let's say, the accused without having the complete and final version of events from the previous people you've interviewed. So you need to build in pauses to make sure that the documentation you've got is accurate. And so quite often when I'm interviewing people, they'll say, "Oh, Simon, I remember there was some emails I sent around that time. I'll go and dig them out for you. I'll need to go back through my files." Or, "Yeah, I did actually make some notes about that." So you'll need to make sure that you get hold of that before you proceed. So again, it's important that you're building in pauses into the investigation to make sure you've got all of that information, so that when you come to do the next interview, the evidence you're giving and putting to the next person is as accurate as possible. So whilst we're talking about prioritizing investigations, it's important that you're not rushing it, and you need to build in pauses to gather the evidence, check the evidence, and make sure that it's final versions and it's not likely to change. So the next thing to think about is messages. So when someone has had a traumatic event, they may well have blanked out or not remembered completely what's gone on, and often it's in a situation of one word against another. So one thing to do is to remind the person or ask them, did you send any messages or contact anyone shortly after the event? And it's worth reminding that, because there is some statistic that the vast majority of people won't tell their employer about an event, but they will tend to tell a friend or family member afterwards. So it's worth asking them, did you send any WhatsApps straight after? And it's often the case that they will have put a post to a friend on social media, or sent a WhatsApp, or sent a message. So it's worth asking them that, and if they can dig that out, and that's often very good evidence, because that is contemporaneous evidence shortly after the episode we're talking about. And then the last bit on this is confidentiality. So this had a number of limbs to it, and it really touches on what we've talked about previously about what may happen to the evidence. So it's important that throughout the process, you're emphasizing the need for confidentiality to everyone. So when we're doing investigations, we send a confidentiality reminder before the interview when we're setting the interview up. We are then at the start of the interview reminding them of the need to keep the information confidential. So throughout the interview process, it's important that everyone is told to keep the information confidential. We're obviously external investigators, but quite often the client or the employer will send a confidentiality reminder, and will add in something along the lines of, and a breach of confidentiality may well result in disciplinary action being taken, to emphasize the importance of the need for confidentiality. So that's one side of the confidentiality coin, but the other side is then what will happen to that evidence afterwards. And that's comes back to the point I made previously, that you can't give promises about who may see that evidence, because in order for that evidence to be tested, and you need to so you can talk to people about that evidence, you need to put that evidence to other people. So it's important that you're clear that that's what you may have to do as part of the investigation. And that others may see that evidence. So you may then need to think about, if, for example, someone has talked about someone's sexual history, you may need to think about, well, redaction of that sort of thing? Does that need to be, before that gets forwarded and submitted as part of the investigation report and as part of the evidence, should I redact that information? Because is that necessary or appropriate for that potentially to be shared with a number of people? Because once the investigation report and the evidence and all the appendices is compiled, sometimes that can be shared. And so it's important to reflect on, do we need to redact or remove certain bits of evidence before it gets appended to the investigation report? Right, let's move on to the next slide, please, Lisa. Right, so as external investigators, this is something we often don't get involved with because we're brought in just to do the fact finding. But certainly from an organization's perspective, it's important that the employer is signposting any follow-up care, any employee assistance programs, any counselling resources that may be available. It's important to look into that, I think, at the start of this process, because as sort of empathetic and considerate and patient as you can be as an investigator, you are going to be asking people to revisit some very difficult periods. And so it's important that there's that follow-up care. And our experience is, unfortunately, following interviews, people need a bit of time off because they've obviously had to revisit some very difficult periods. And so it's important that that care is provided to everyone involved, and they can be signposted to any resources. And then it's important, again, it's the flip side of what we were talking about earlier about the timings, is to maintain transparency. So at the outset of an interview, we will say what we will be doing, where the evidence is going to be going, what the next steps will be, and that they are clear, the people involved are clear what is going to be happening next, and feedback. So again, as external investigators, we are often not the people to provide the feedback, but it's often the organizations themselves who will provide the feedback, who will keep the people involved up to date with what's happening. Now, that's not to say that you need to give them chapter and verse about all the decision-making process and where the considerations are and what's going to be happening next, in terms of next disciplinaries, etc. But so I think that there's a limit to what you need to feedback, but certainly I think a feedback about the process more generally, about where it's got to, just because there can be a feeling of just being sort of being left in a bit of a void. And so it's important that the people know that it has been requested, it's being treated seriously, and steps are being taken, so it's not just being shelved. So it's because if they're not hearing anything, then they may just assume that nothing's happening. So it's important that they're aware that a process is being taken. It's also aware that these processes are usually not quick. Investigations, particularly with a number of witnesses, are not quick because there's often delays when people go absent due to sickness, due to annual leave, etc. So there may be a number of scenarios that are going to cause delay, but again, it's important that the main protagonists involved are kept in the loop about progress. So can we move on to the next slide, please? Right, so you've conducted all of the interviews, you've gathered all of the evidence, and my experience has been that we talked a lot about the interviews, but I find often some of the most important evidence when I'm coming to write my report is the contemporaneous stuff, is the WhatsApp messages, are the emails that have been sent following a difficult meeting, interview notes, so meeting notes, meeting minutes, that sort of thing. So it's useful and important to make sure you gather up all of that. And certainly my standing request when I'm doing interviews is any document that you mention, I'll want to see a copy of. And I often have to send reminders saying, you mentioned this, can you please send me a copy of it? And so it's important that it's not just the interview evidence, because often with interviews, you are going back over things that have happened weeks, if not months ago. And so often the contemporaneous evidence, the emails, the WhatsApps that were sent at the time are often more accurate than someone trying to remember something that's happened several weeks ago. So when you're preparing a report, it's important that it's a priority, but you mustn't rush it. So it's important that you've gathered all of the evidence. You don't want to be writing a report on half, 3/4 of the evidence. So you've gathered all of the evidence. And then you've had a chance to sort of distill out what are the key elements I've been asked to look into from the terms of reference. And then the terms of reference will hopefully set out essentially the key questions that you'll need to address. You need to address the evidence in respect of each of those particular questions or particular allegations. So you set out what you consider as the key evidence, and you need to reflect all the evidence. And this is the same in any investigation. This is probably the most important point of all of my points, is that there can be a risk where you're dealing with a particularly serious and sensitive allegation that you will want to just effectively find evidence that supports a particular case. If it's particularly concerning what's been alleged, there can be a risk that you're just going to go, well, I'm just going to find the evidence to support this. But there will usually be another version of events, and it's important that you reflect both the versions of events in your report, and you assess all of the evidence. So you don't gloss over it. You say, well, and this was the other version of events, and this was the evidence that they provided, and then you assess the evidence. But it's important that it's a balanced report and you're reflecting all of the evidence, because your role as investigator is fact finding, and so it's important you gather all of the evidence and you reflect all of the evidence. And then there's just the reminder, final bullet point there is just a reminder about what you're going to do with that confidential and anonymous evidence. So the confidential is, let's say, the information, let's say, about someone's sexual history. Should you redact? Should you remove it? Should you put it in a separate appendix, which doesn't necessarily get shared? And how you're going to handle that, because again, it's that question of, well, who else is going to see this? And these investigation reports can sometimes sort of take on a life of their own, because once they've been submitted, you can get tribunal disclosure, subject access requests. So you've got to be quite careful and think through quite carefully about what you're going to deal with that. And the next one is anonymous information. Anonymous information is, we find, quite challenging to deal with, because if you've got someone who says, well, I want my evidence to be kept anonymous, quite often it's not possible to keep evidence anonymous, because it's fairly obvious who we're talking about. Let's say there's been an incident with two people and there was a third person in the room or nearby who witnessed it. It'll be fairly obvious who that third person witness is. And so it's, even though they may say, well, I want to be anonymous, you can't really make that evidence anonymous. And the next thing is that you've got, in order to be able to make evidence anonymous, you often have to strip out so much information, there's very little left. And so the question is, well, what's the value of that anonymous evidence? And the other point about anonymous evidence is that the person who is being asked to respond to that evidence, they're often put at some difficulty. They say, well, how can I respond to this? Because I don't really know who said it. And it's so, because of what you've had to do to the evidence to make it anonymous, so it's very difficult to make any specific comments. When did that happen? Who was there? I need more information before I could respond. And so So there's a number of problems with anonymous evidence, and so it's something to be avoided in all investigations. But again, if there is an anonymous evidence and it can't be avoided, then I would say that, again, you need to think quite carefully about how you're going to position that evidence, where it's going to be, how it's going to be set out in the appendices to again help preserve the anonymity if a decision's been made. Usually our preference with requests for anonymity is to offer more support, essentially, is to provide someone they can speak to, usually quite senior in the organization, who will provide support and encouragement for them to provide the evidence in a named way rather than anonymous evidence. Right, can we move on to the next slide, please? So this is about investigators. So whilst we've talked quite a lot about the need to be careful with interviewees, investigators need to also think about looking after themselves, because you're often going to be hearing and dealing with and processing, having to sort of reflect quite a lot on some very challenging and disturbing information. So I find talking to colleagues about it afterwards, just to have sort of debrief about, so, well, this has just happened, have you had similar cases? And so it's useful to talk to people afterwards, and go for a walk afterwards, and just because you will need a break if you've been listening to some very challenging information, then I think it's worth going for a walk, and just to make sure that you're looking after yourself and not just trying to plow on, because there's no point trying to pretend that this is easy. So it's important that if you are dealing with challenging information, that you deal with that. I did one about a year or so ago with some very challenging, some very upsetting evidence, and I shared that. Me and a colleague sort of did the investigation between us, because it was just easier rather than effectively carrying it all on your own. So it's worth thinking about that. Right, let's move on to the next slide, please. So this is just really a reminder from the point Lisa made earlier, that this has really come about because of the duty to prevent sexual harassment, which came in October 2024. And this discussion about trauma-informed investigations came about because of the Equality and Human Rights Commission, their technical guidance, which said, as part of the toolkit for employers, you need to train your investigators on carrying out trauma-informed investigations, because if you've got a culture where people who come forward who've claim they've been, let's say, sexually harassed, if they feel that the process has exacerbated their trauma, then you are probably failing in your duty to prevent sexual harassment. So this is why we are talking about this now, is because it's part of your legal duty. It's part of the toolkit that the law now requires you, or the guidance now requires you to adopt. So it's important that you, as an organization, when you're dealing with cases of sexual harassment, are dealing with them in a sensitive way that is not going to re-traumatize, because you don't want a situation, a culture developing where some people say, well, don't put your hand up, don't complain, because X person went through that and it was just so much worse for them afterwards. So it's important that that you are aware of your duties, and you are this is part of the toolkit to discharge your duties, and to promote a safer workplace culture where people feel they can come forward, raise complaints, and those complaints will be dealt with respectfully and sensitively. So we're not saying that just because someone comes forward that they automatically need to be believed or anything like that. But what we are saying is that the process you follow, the investigation process you follow, needs to be done in a trauma-informed way, so that the process you're following is not going to exacerbate the trauma that someone is saying they've suffered. So let's move on to the next slide, please. So what are our key takeaways from this? So the trauma-informed practices are essential. It now needs to be part of your toolkit. You need to not be in a position where people don't want to come forward because they're concerned that things are just they're going to just end up feeling a lot worse. Prioritize safety, an empathetic approach where you're recognizing that these are difficult things that you're asking them to talk about, being very patient and transparent about the process, so they don't feel like they've just been left alone and they're not clear what's going on, and they're not sure if anyone's progressing it. Has it just been shelved? So it's important that you are transparent. You'll say, look, this is the process we're going to follow. This is our hopeful timescale, and to keep them abreast of that. And importantly, support for both interviewees and investigators. These are challenging matters that you're going to be dealing with, and so it's important that both interviewees and investigators can be supported. So next slide, please. Right, now let's
Okay, so let's have a look at the Q&A box. We've got 6 questions that have come in there, and I will just pick a couple of these. So one of the questions, which we see a lot actually, can the investigator recommend next steps such as progression to disciplinary, etc.?
The answer, shall I answer that?
Go ahead.
The answer is yes. That's the extent of it. In investigators, you have to stay in your lane, and so you're often asked to make recommendations, and that would be the extent of your recommendation. Is yes, I recommend that these particular allegations be treated as a disciplinary matter, and this person be asked to address them in a disciplinary hearing. You must never go beyond that. You must never say, oh, and by the way, I think this is gross misconduct or anything like that. But it's yes, as a fact finder, it's one of the things you're often asked to do, is to make recommendations, and that's certainly often the main one.
This is an interesting one. There was another one that I thought was interesting. Should we ensure that a friend that attends in support of a complainant signs a confidentiality agreement? So I think that's sort of often when we're interviewing, we will inform the person we're interviewing that they need to keep the matter confidential. So this is about whether those attending in support, accompanying them to the investigation meeting, should be asked to sign a confidentiality agreement.
I'm not sure I would ask them to sign an agreement, but I'd ask them to agree. I'd read out the confidentiality thing with them there, and I'd ask them to agree to maintain confidentiality. I don't know about
you can also do that, can't you, when you're inviting everybody to the meeting? In the first instance, outline it in that first email. Explain that this is a confidential process, and it's important that it needs to remain confidential.
And quite often, because these things are often hammered out before the process, before the interview itself, they'll often say, can I be accompanied by X person? And you will often say, well, yes, but they need to agree. They need to agree to keep the matters raised and discussed confidential. So yes.
There are loads of brilliant questions here. We're seeing more and more group grievances, which have been very difficult to manage. Can you recommend an approach in handling this well?
I don't mind answering this one, as I'm in the
Yeah,
middle of doing almost a group grievance as it stands at the moment. I think it's often difficult to handle a group grievance in terms of the evidence and losing track of where you are as an investigator. So the first thing that I've done in the latest group grievance that I've been dealing with is split everyone up and put them into their slots in terms of what their actual grievance is as an individual as part of that group grievance, and break everything down into individual grievances in that sense, and organise the questioning like that and the evidence in that way. So it makes it much easier to handle, because although they're often group grievances, there are often actually some individual elements within that. I don't know if you've got anything from your experience, Simon, to add to that.
No, I think the sort of dividing them up, because you often find that essentially they're sort of parroting each other's evidence, and so when you get them individually and say, right, what are your particular complaints, and they often boils down to, well, I'm friends with X and I'm really supporting them. So, but it's important that you ask them, but what's your specific grievance about this? And so it's important, I think, to sort of put, as you say, pull the strands apart. I would avoid having a sort of a meeting, a group meeting, because you sort of get that sort of wisdom of the crowd, and you don't, it gets, you don't really know whose evidence it is when people sort of shouting out. So I wouldn't do that process. I would meet with them individually and deal with it that way.
So this is one about well, I'll read it out. Can you issue a management instruction for an employee to attend and share information they know in relation to it, with a statement that if they don't, they will be subject to disciplinary action? So can you force someone to be a witness? Is sort of the question.
Well, my short answer is yes. They are. It's a if because it comes back to that sort of principle of, well, is it a reasonable request? If it's a reasonable request you as the employer are making, then if they don't comply, if they refuse to cooperate, that's a breach of a reasonable request, which then becomes a disciplinary issue. So I guess the test is, was it a reasonable request? So that will be the big question. But usually if they can give relevant evidence to an important matter, I would say yes, it's a reasonable request, and they can be disciplined for it.
Often what we find is that people are reluctant to give evidence because they're worried. So perhaps they might be somebody, a more junior member of a team, and they are worried about repercussions, negative repercussions for them. So how do you deal with that sort of scenario?
From my perspective, I've had people in the senior people within the organisation offering reassurance to them that there will be, there will be no repercussions in terms of providing evidence. But I've had a scenario quite recently where I've had two people in an investigation who did not want to give evidence, and they cited their mental health and well-being in terms of that, and that the whole process is making them unwell. So in combination with the client, with the organisation, we had a look and to see just how important was their evidence. Was it going to be make or break? And did we need to, come down hard and say, no, you have to give evidence? And in this situation, they were periphery witnesses. So we decided that actually, we're not going to force the issue on this occasion. But I agree with Simon, if it's essential information, then, it's a reasonable instruction.
And it becomes more challenging when you've got less sanctions. So when people are leaving or have left, then that becomes really difficult, because often they won't cooperate, and you're not the police, you can't force them to cooperate. And so yes, that becomes more challenging. So I think with your current employees, then yes, I think it's a reasonable request. And if they continue to refuse, then I would start talking in terms of, well, disciplinary action for failing to cooperate.
We've got one here about, so you've got a sexual harassment grievance that's been lodged by an individual. And the scenario is that the person that has raised the grievance, you've asked the person that's raised the grievance to keep it confidential. And the person that's raised the grievance has been discussing the sensitive details of their grievance with a colleague who was then told lots of other people, and so news has got out. How do you deal with, I mean, clearly that's somebody who's in that kind of situation of having raised a grievance may want someone to confide in. Equally, you've got then a situation where something's leaked and has become perhaps the subject of a rumour mill, and you've also obviously then got somebody on the other side who is possibly the person accused of the sexual harassment. How do you navigate your way through that situation? It's a tricky one. I mean, my initial thoughts are you might often have somebody who you appoint as a point of contact within the organisation from a sort of welfare and pastoral perspective to give that individual a point of support and a point of contact. Any other thoughts on how you might deal with that?
I think it's important to stress to the individual that the confidentiality is important for them to maintain the integrity of the investigation itself. If they are talking to everyone about what's happened, it could contaminate the evidence in terms of witnesses. It just creates a difficult environment. So it's important to go back to the individual and explain that clearly, and explain that they are under a duty of confidentiality and that they shouldn't be discussing this in the wider context. But obviously, as you say, they may have discussed it with a colleague or a friend, or in terms of requiring that emotional support. And if that's the extent of it, then that's a different scenario. But if it's all of a sudden widespread discussions in the office about the situation and that you're aware of that, then you perhaps need to deal with that on a wider scale, then explaining to all of the colleagues that there is, that please do not discuss confidential matters and investigations that are underway.
Yes, because you've got to give everyone the opportunity of a fair hearing, and you've got to avoid effectively these colleagues sort of trying it in public and discussing it and making them drawing their own conclusions, and creating a situation where the person, let's say the person accused, is going to find it very difficult to carry on working there, even before you carried out your investigation. So yes, I think just the importance of emphasizing the need for confidentiality. It's a balance. You don't really want to start talking about disciplining the person who's raised it, but that ultimately is the sanction. It's a very sort of blunt instrument, but that would be absolute last resort. And it may well be that the person who is talking about it more is the friend. She's put it on, he or she's put it on social media, etc. And so that's it may not be necessarily the person, you know, who's the initial person who did the initial leak, as it were. It's the person they said it to that has really run with it. So it's very tricky, very tricky.
Lots of things to think about. Thank you everyone for joining this morning. I'm conscious we're at 10 o'clock, so we will bring the session to a close. We will send a follow-up. If you could just stay on the line for a minute or so just to complete the poll, that would be much appreciated. Any ideas for future sessions, please feel free to pop those in the chat box. When the follow-up bit comes out, there'll be all the details of the next event. But thank you very much.